Hello, everyone. My name is Andrew Nyamayaro, and I'm here to present to you the usual conversations that we normally have. And I am a solicitor at Tanlo Solicitors. I'm so glad that last week on Friday, and today being the 17th of November 2021, on Friday, we won an award here. We won an award as the best firm of solicitors in the category of 1 to 5 partners in the Warwickshire County or in the Warwickshire constituency. So we are so happy that we've been recognized for our hard work that we do for our clients and for our community and for everyone who is involved with us. As you would know, we've won several other awards in the past. So this is a recognition of the hard work that we are doing, and we thank all our clients. We thank all our stakeholders and everyone that is involved, our staff that is involved with the firm. Further to that, I'm also glad to announce that Tanlo Solicitors is now part of the Quality Solicitors Network, which is a network of a firm of solicitors all over the United Kingdom, so that we also have to rely on the numbers of other firms as well, referrals, and networking with other solicitors. In addition, Tanlo Solicitors is also now part of LawShare, another network of law firms or solicitors firms in the United Kingdom. This is to bolster our presence and our recognition amongst the firm of solicitors that are in the United Kingdom, England, and Wales, and indeed in the world. Today, I want to present to you about the concession that has been made by the Home Office, which is quite an interesting concession and which will help a lot of our clients or potential clients. So the Home Office on the 21st of October 2021 issued a new guidance or a new concession, and the concession which I'm holding here, you can download it. It's available on the gov.uk website. It's entitled Concession to the Family Immigration Rules for Granting Longer Periods of Leave and Early Indefinite Leave to Remain. This concession is mainly targeted to young adults, people that are aged between 18 years and 24 years that came to the United Kingdom, or at least they were still young or were born in this country, but their parents or guardians or whoever was responsible for them didn't have any leave to remain or any visa in the United Kingdom. Ordinarily, when someone is granted leave to remain, they may be granted leave to remain either on the 5-year route or on the 10-year route. The people are not normally granted indefinite leave to remain straight away because the authorities in the United Kingdom wants to give them a probationary period of them integrating themselves and settling themselves in the United Kingdom before they are made permanent residents or eventually become residents or citizens of the United Kingdom. So 5-year route is normally reserved for the people that have been in the country legally, they've come legally, and they are extending their visas, and or they've been born when their parents have had some legal stay in the United Kingdom, and so they are just extending for that period as necessary. However, the 10-year route is given to people who, in a way, might have been in breach of one or two immigration rules, that have not been complying with immigration rules, and it is normally granted under exceptional circumstances and compassionate circumstances, or where as it is provided for in the immigration rules, where someone has been given discretionary leave to remain. So that's where they will be put on the 10-year route. So the 10-year route generally serves as an incentive to encourage compliance with the core requirements of the immigration rules and encourage integration into society. However, what the courts have realized, and they've always said, and the Home Office has now agreed to and issued the concession, is that in most of the cases, children are put on the 10-year route or are punished for the um, wrongdoings or for the miscomings or um, non-compliance of their parents. So if someone came with their parents and the parents didn't comply with the immigration rules, they entered the United Kingdom illegally, or they allowed their visa to lapse one way or the other, and now they're trying to regularize their stay. Their children are also punished alongside that. And it becomes more difficult as they grow and maybe try to establish their own independent lives. So the Home Office has issued this guidance or this concession, particularly targeting young adults between the ages of 18 to 24, 25 years. Um, so this concession, and I will read verbatim from what it says on the concession. That is on page 4 of the guidance. However, in some cases, the public interest factors which underpin the 10-year settlement policy, namely the need to serve a longer probationary period before qualifying for settlement and the principle of encouraging lawful compliance, may be less relevant. In particular, this may be the case for those applicants who were born in the United Kingdom or entered as children below the age of 18, but are now young adults aged 18 to 24 who cannot be considered responsible for any previous non compliance with immigration laws and are fully integrated into society in the UK. For these individuals, it may not usually be proportionate to expect them to have to complete a longer 10-year route to settlement. Where that is the case, they should be able to settle after 5 years continuous leave. So if someone is aged between 18 and 24 and they've been in the United Kingdom for quite a long time, who could say maybe half of their life or even more or less, but a long time, then they can fit into this compliance. I'm going to come to the requirements next. Um, what I've noticed in practice is that this is the age group that struggles a lot when it comes to university funding because they are not on settlement. Some universities or even the student finance causes a lot of stress to the young adults who want to go to university. They still treat them as international students, even though they've been in the country for more than 3 years. Sometimes they do not accept them. It looks like the policies for the universities differ. Although, to my recollection, there is a case law which says that where someone has had legal leave to remain in the United Kingdom for 3 or 4 years, they qualify for student finance. In practice, this is almost difficult depending on the university that someone is going to go to. I always have those inquiries from parents or the young adults, and they may be forced to go to work and defer their university places. So let me go back to the concession again, to the guidance. For children aged under 18, the current private life rule will still apply as in their case, the instance of having spent time in the United Kingdom as a child but now having to apply as an adult does not apply. In their case, the presumption is that they are seeking to live in the United Kingdom as dependents of their parents. Similarly, the concession does not apply to children and young adults when the parent, guardian, or a family member on whom they are dependent is applying or is eligible to apply under Appendix FM. They can be expected to continue to be granted leave in line with their parent, guardian, or family member on whom they are dependent. So for those ones who are still dependent on an adult, they will still be considered under the normal rules of the 10-year route because they are seen as dependent on their parents, and the parents cannot be fast tracked to um, indefinite leave to remain. It is only the young adults who are in a way becoming independent from their parents and therefore can then qualify on this concession. Okay. So the important part that I want us to understand and to know is the criteria for the applicants under the concession. To be eligible to be considered under this concession, an applicant must, and that is at the date of the application, one, be aged 18 years or above and under 25 years of age, and has spent least it has spent least half of his or her life living continuously in the United Kingdom, discounting any period of imprisonment. So the person should have spent at least half of their life in the United Kingdom, aged between 18 to 25. Anytime that they spend in prison is not counted, it will be discounted. So if someone was in prison for 6 months, then that will not count. Two, you've either been born in or entered the United Kingdom as a child. Three, you've had 5 years limited leave. So this person should have spent at least 5 years in the United Kingdom. Even so, maybe they've done 2.5 years, extended for another 2.5 years. They're now over 18, but under 24, so they can make an application under the rules or under this concession. Be eligible for further leave to remain under paragraph 276A(DE)(1) of the immigration rules and have made an application under those rules. So if someone has made an application, that would have been maybe an application for limited leave to remain, but in the cover letter or in the statement, it is explained that they've been here for more than their life, they are over 18 and under 25, the evidence is submitted, then the Home Office under this concession would consider to grant them a longer visa or alternatively settlement under this concession. So there is a various considerations that the Home Office will take into account for them to reach the decision. So they look at the person's age when they arrived in the United Kingdom, the length of the residence in the United Kingdom, the strength of their connections and integration in the United Kingdom, whether unlawful residence in the past was as a result of non-compliance on the part of the applicant or their parent or guardian, whilst the applicant was under the age of 18. What efforts were made to engage with the Home Office to regularize their status? Any leave or a visa currently held and length of continuous lawful leave or a visa. Any period of continuous leave held in the past. The word leave, we commonly call it a visa, but technically it's a leave. Whether and to the extent to which limited leave to remain will have a detrimental impact on the person's health and welfare. And then when we look at welfare, we mention things like going to university and so forth. So it has to be considered what impact it's going to have. I believe that this is going to help a lot of young people who are in the United Kingdom and who are on the 10-year route so that they can be fast tracked to the settlement or to have a longer leave to remain and since they've already integrated and they've settled themselves in the United Kingdom, this can be of benefit to them. Whilst I'm speaking of young adults and also referring to children, I also want to highlight that where someone has been born in the United Kingdom and they've spent the first 10 years being a resident of the United Kingdom, then they can qualify to be registered or to naturalize as a British citizen. For all these applications, there are fees to be paid. And for someone to naturalize as a child, I understand and I know that the court said that it is unlawful for them to pay the Home Office fees, or at least the current fee. But the Home Office has not yet changed that. Whether they will reduce it or cancel it, something that has not happened. There are also various ways and means in which children can qualify for British um, nationality, maybe having spent a period of time on limited leave, then getting their settlement, and then becoming British citizens through naturalization or being born in this country, and sometimes through ancestry and so forth. It's things that you might need to get legal advice on. As I conclude, please treat this presentation as general information. If you require specific legal advice, please consult with your lawyer or contact Tanlaw solicitors when they should be able to take instructions from you and deal with your case as an individual rather than as a generalized presentation. Thank you so much for listening to my presentation on young adults, long visa or indefinite leave um, or settlement concession. And thank you so much for the support that you always give us, hence getting such accolades like this award that we won last week on Friday. And we continue to rely on you. And thank you so much to our clients, to our staff, to our stakeholders, and everyone that deals with Tan Law solicitors. Thank you.